Welcome back to the second part of this video lecture on this week, when we're recapping over some of the important topics that we've been through over the past few weeks. So let me stuff myself back in the corner, and we'll push on now with the first of those important topics, which is the basic principles of law, sources of law, and the basic divisions. So just to run through those. We did these in week one, remember? So I really want you to get a really good foundation to the reason why the law is structured in the way that it is. And I think it's important you understand there's this constant balancing act going on within the law. So fundamentally, there's this drive for open justice, and that's what we as journalists are really keen. And we rely on open justice, that we're able to report what happens in the courts, and the courts recognise that, and they have spoken about they enshrine the principle of open justice in their rulings. That justice must not only be done, but it must be seen to be done as well. It's a really important principle. However, balancing that out, and something which curtails and limits open justice are these two things: a presumption of innocence. Somebody is not guilty until a court has found them guilty. So we cannot just go out there and start publishing material which suggests that someone is guilty until they have been actually found guilty. And also, there's a right to a fair trial. So we need to observe the rules which are issued by the court, which protects that right to a fair trial, so that anything we do as journalists, as members of the public, members of our community, is not prejudicing a trial. That somebody can have a fair trial and they can be presumed to be innocent until they've actually been formally found guilty. So it's really important you get that basic balance, that tension which is taking place within the law. So we talked about the sources of law. So we talked about all of these. So we talked about statute, which is law that comes from Parliament. These are acts of Parliament which are passed by MPs, and so this is what they call laws which exist on the statute book. They're written down. There's common law, so this is law which has come down to us through the ages. It's not written down in any particular place, and we went through some examples of some of those sort of slightly quirky, old-fashioned laws about it's illegal to die in Parliament, things like that. But there are some very important laws which come to us through common law. Think, for instance, murder is an offence under the common law. It's always been illegal to murder somebody, and so there's never been any reason to actually pass an act of Parliament against murder, because we have common law. Case law, so this is the law which is created by the judgments take place in court. So if a judge makes a ruling based on certain principles, those principles also apply to all other courts at the same level and below. When you see great big piles of books in lawyers' offices, quite often those are the lists of precedents of decisions that have been taken in other courts. And the idea behind this is obviously that everybody is using the same principles to come to decisions. And Europe is also another source of law. With the European Convention on Human Rights, is an important source of law, and remains so even after Brexit. So once we got through the sources of law, we then looked at those basic divisions of law. That there's a fundamentally divided between criminal law and civil law. So it's important you understand the distinction between those two areas. So let me just talk about those briefly. So the criminal law, you'll remember, are offences which are deemed to have been committed against society, against the whole community. And the way we express that legally is that it's an offence against the crown, against the Queen, as we have at the moment. So the title of the case would be recorded as R. R stands for Regina. If we had a king, it would be Rex. So R versus Ian Wood. So it's the crown versus Ian Wood. So if I've murdered somebody, or I'm accused of murdering somebody, that's a crime against society. Therefore, it would be the Crown against me. So an important point to remember about criminal law is that the burden of proof is very high. It has to be beyond all reasonable doubt. So you have to prove the case beyond all reasonable doubt. And there are specific courts which hear criminal cases. So those are things like the magistrates and the Crown Court are specifically criminal courts. The other type of division of law is civil law, and that is the area of law which deals with disputes between individuals. And so in those cases, you get the name of the case would be expressed as Wood versus Smith. So it'd be two individuals or two companies potentially involved in legal action. And so these are disputes between individuals, and the burden of proof is lower. It is beyond all. It's proving guilt on the balance of probabilities. So it's important to know that civil law has a lower burden of proof, and they deal with a different set of courts. Most civil cases are heard through the county courts, which is a civil court. Right, some basic definitions which you need to be aware of. So we need to know who the defendant is. So the defendant is the person who's been accused of the particular crime. It's important that you are aware of different types of lawyer that you might encounter in court. So you might encounter a solicitor. Now that's the person, the legally trained person who will deal with the client, and they can appear in a magistrate's court, but they don't have what they call rights of audience any higher than that. So a solicitor could not address a Crown Court, which is a higher criminal court. A barrister, on the other hand, is the lawyer who does have a right of audience in the Crown Court, and the barrister is the one who wears the wig and the gown. Now they're briefed by the solicitor, and they represent the case in a Crown Court. So they're a more senior type of lawyer. The age of criminal responsibility is important. So that's the point at which you can be accused or can be charged with a crime. That's 10 years old. If you're below 10 years old, you can't be charged with a crime because you're below the age of criminal responsibility. Also, there's the question that often comes up is, what is an injunction? So an injunction is an order from a court to either do something or not to do something. So if a court issues an injunction, it's an order and you must follow it. Okay, I'm going to finish this short video here, and then I'll move on to the next video where we'll talk about the courts.